What's up, everybody? Welcome back to another episode of The Lawyer You Know. And today we're going to be breaking down the actual order in the Lively Baldoni case from their initial hearing, which sets out exactly what's going to happen in this case and how it's going to go from the judge's point of view. It was widely reported as a major victory for Baldoni and his team, and yet another blow for Blake Lively and her team, but I'm not so sure I agree. So we're going to take a look at exactly what the judge said and how it's going to affect what everybody's been publicly saying about how they're going to handle this case going forward. So it's a pretty short 2-page order, but there's a lot of implications that we can see, and we can learn a lot from this order as we're going to read it together. And we're going to start off with the fact that there were no cameras in this courtroom. So we're going to be getting a lot of reports and people's point of view and how they think it's going. We're going to have a lot of people commenting online about things, but it's so much harder to get it straight from the record and straight from the lawyer's or the judge's mouth. And we saw Friedman's interview outside the courtroom, how quick it was, how tight-lipped he was. He didn't say much. He definitely didn't expand on anything. It definitely seemed like a different vibe from him, even though for all intents and purposes, everybody was saying huge win for Baldoni and his team because the judge did not issue a gag order and they didn't make them take down the website. And it didn't seem like they did anything official to shut either side up. Well, let's take a listen to the order here. This order memorializes rulings made at the initial pretrial conference held on February 3rd, 2025. All parties appeared at the conference except the New York Times Company. And they've consolidated all of this together. And we're going to get confused. I'm sure I'm going to say California. I'm sure I'm going to say New York. There's all sorts of things going on in this case, but they're trying to consolidate them to where the same lawyers and the same people don't have to do things in 5 different jurisdictions, which has not been served as of the time of this conference. The case management plan proposed by the parties is adopted with certain modifications. As set out in the separate case management plan and scheduling order, the case management plan is adopted without prejudice to a motion to amend such plan by any party after the filing of the amended pleading, or by the New York Times after it has been served and appears in the case. The parties shall submit a proposed protective order no later than March 11, 2025. If the parties are unable to agree on a proposed protective order, competing versions should be submitted by March 11th, 2025 with legal authority. So that's the first big paragraph I want to talk about. And if you can't read it, don't worry. Like I said, I'm going to read every single word here. We're going to break it down together. So the parties shall submit a proposed protective order. We've seen protective orders in other cases. This can apply to a number of things. Number one, it can apply to discovery. It can apply to witnesses. It can apply to depositions, potentially. If you want to block somebody being able to take a deposition, you can file a motion for protective order saying, Judge, it's unfair, or they can't take this deposition. It's harassing. There's no reason to believe that this is going to lead to any discoverable material. They're just doing this to bother one side or the other. You can file that in the form of a protective order. But this is most likely having to do with the initial discovery that's about to take place. And you can file a protective order in any case, right? This needs to be confidential. This needs to be protected, Judge. We shouldn't need to turn this over. A lot of times they ask for certain medical records that we think are just absolutely asinine and have nothing to do with the case in a lot of my cases. So we'll file a motion for protective order. But this is indicating to me that at least one side has already said, Judge, this is going to be sensitive material. It's already been publicly disseminated. We see people are going wild with this. It could potentially poison a jury pool. We need to have a heightened realization in this case that there are certain things that we need to keep private. These are celebrities. These are personalities that people are going to be interested in. And we don't want to go digging into their private lives unnecessarily. Now, part of you will say, well, you've chosen to file this lawsuit. Each side is a plaintiff in a lawsuit, right? They're each suing each other. So they've both chosen to be in lawsuits at some form or fashion. So you know you're opening yourself up to certain discovery. So why should you get a protective order? And what this tells me is the judge is considering protective orders, but not guaranteeing it. And if they can come to some agreement as to what is going to be protected, then the judge is going to rubber stamp it and say, that's fine. If all you guys want to protect it, we'll protect it. But if they agree on a protective order, that means that information is not going to be public. So what about Baldoni and his team saying, we're going to create a website and put everything out there for people to see? Well, are they going to pick and choose what they put on there? Obviously, like we talked about in the other day's video, when we talked about what you can and can't put on a public website, things that are confidential, things that are protected, things that are sealed, or things that are subject to a protective order or confidentiality of some sort. If they sign some agreement that we're not going to reveal certain details, maybe like, I don't know, the contracts that they signed, how much they get paid for a movie. I don't know. That might be protected. That might be confidential. So is this website really going to have everything? Or are they going to have to back off on that? Is this the judge's way to not allow them to post stuff on the website? Is this going to be Blake Lively's way to block certain information without a gag order officially by the court? I think it may be. And the court also understands that while one side might want a protective order or both sides might want it, they might not agree on the details. And if they don't agree on the details, what do? Each side files what they believe should be the protective order in this case. That's why it says competing versions should be submitted. So if you can't agree on one unified motion for a protective order, on what we're all going to agree is protected, let's see the two sides and file it with legal authority. What do I have to do as a judge? What do I have to protect? What should I protect? What should I not protect? Because transparency and the public interest in this case is important, and we have to make sure we balance that with people's privacy interests that are involved in the case. Next paragraph. Motions to dismiss and motions to strike shall be filed within the deadlines set out in the Federal Rules of Civil Procedure. Motions to strike should be made by formal motion pursuant to Rule 1C of Judge Lyman's individual practice and civil cases, individual practices. The parties shall follow Rule 2.1 of the individual practice regarding page limitation for briefs. So those are all just, hey, follow the rules I post personally as the judge. You have to follow my rules, but we're also going to just follow the Federal Rules of Civil Procedure. And then lastly, we heard a little bit about this, and there's just one little thing I want to highlight. By consent of the parties, meaning everybody agrees, Rule 3.6 of the New York Rules of Professional Conduct is adopted as an order of the court applicable to all counsel of record. Breach of this rule may be punished pursuant to Rule 16F of the Federal Rules of Civil Procedure or the court's inherent powers. Okay? I'm going to look up Rule 16F to read it with you guys. Just so you can see what the actual language is of it. All right, so let's read 16F together. But first, I want to mention a couple things before we get to 16F. So adopting Rule 3.6 for these lawyers, it already was in effect, right? As far as ethics goes, as far as you could get in trouble with your bar card, with your license, you don't want to get in trouble ethically by violating Rule 3.6. So it's no surprise to me that both sides agreed that Rule 3.6 was going to become part of this case, and they have no problem with it. And neither side is going to agree or think that their lawyers violated Rule 3.6. They might say the other side did, but they'll have their arguments, they'll have their reasonings for what they said and how it fits into Rule 3.6, and we've discussed that ad nauseum. But what difference does it make that the rule or that the judge is actually going to submit this as an order in this case? Well, we know that you can be held in contempt, and we watched a lot of this in the trial with Brian Steele when he was held in contempt and thrown in jail, that if you violate a court order, you can be thrown in jail as a lawyer for violating a court order. You can be sanctioned, and that is all an additional step, an additional layer of potential punishment that is going to make you make sure you're on your best behavior. So it didn't change anything that the lawyers should have already been abiding by those rules. It just elevated the potential sanctions. So let's look at Rule 16F of the Federal Rules of Civil Procedure. In general, on motion or on its own, the court may issue any just orders. So now that Rule 3.6 is an order in this case, it is now subject to this rule because the judge has issued a just order and the parties even agreed to it. Those authorized by Rule 37, if any party or its attorney, A, fails to appear at a scheduling or other pretrial conference, B, is substantially unprepared to participate or does not participate in good faith in the conference, or C, fails to obey a scheduling or other pretrial order. What can the court do? They can impose fees and costs instead of, or in addition to any other sanction. The court must order the party, its attorney, or both to pay the reasonable expenses, including attorney's fees incurred because of any noncompliance with this rule, unless the noncompliance was substantially justified or other circumstances make an award of expenses unjust. So what does this mean? This means if Baldoni's lawyer violates this court order now, violates Rule 3.6, he could have ethical concerns, obviously, because he's a lawyer and those rules govern lawyers, but now he can also get sanctioned, and any other sanction can also be thrown in jail, like we saw with Brian Steele. So he could potentially be thrown in jail. But if Lively's team has to file a motion and do research and say, look, judge, he violated Rule 3.6. Let's have a hearing on it. I've got to prep for the hearing. I'm going to go handle the hearing. It's a 30-minute hearing or a 1-hour hearing. Now you can be sanctioned and have to pay all of Blake Lively's attorney's fees that she had to pay for them to file this notice with the court and push the court to rule that you have in fact violated a court order. And by the way, sometimes there are discretionary fees in a sanction that a court can give where they can say, okay, I can sanction a lawyer, but I don't have to. It's within my discretion. No. If the court finds that they violated a pretrial order, the court must order the party or its attorney or both to pay the reasonable expenses, including attorney's fees. So if the court finds that either side's lawyer, right, not just Baldoni's lawyer, but this applies to all the attorneys of record in this case, if any of them violate this Rule 3.6, now it is a pretrial order. Now there can be attorney's fees, costs, sanctions, even other sanctions worse, like getting thrown into jail, on top of the ethical concerns. So it was a little bit of a tick up by making Rule 3.6 an order in this case. And the fact that the judge is considering protective orders, I think, is a good sign for Blake Lively if it's her side that wants to kind of block some of the public transparency in this case. I think that's a step that the judge actually is considering it. And the judge does not want this to turn into a circus. Now, whether or not the judge feels like Friedman has already made it a circus or not, or whether those were just appropriately within the Rule 3.6 responses to prejudicial comments made by other people against your client, which I think they firmly fit into. And I think the court could have found that he already violated it, and the court didn't do that. Nobody's actually found that he has violated it. But is this a step in the direction of calming things down publicly? I think it is. I think his very first press conference, if you want to call it that, after this hearing was indicative of that. So it doesn't surprise me that this is how the order reads. Are you guys surprised? Are you surprised based on everything you've been reading and seeing out there? And correct me if I'm wrong, because I've seen this was a huge win for Blake Lively's team. You guys tell me if you agree. I don't think it was anything major either way, but I definitely don't think it was a major win for Baldoni and a major loss for Blake Lively. I don't see it like that. I see this as a federal court judge wanting to handle this case like any other case and not wanting it to become a circus and have the rules followed appropriately, even the rules that already exist. Sometimes judges find it necessary to mention them and go above and beyond and make sure lawyers are doing what they're supposed to. So that's all we got. Another quick update. Let me know if you guys like these kind of quicker updates, just 10, 15 minutes, by hitting the like button and letting me know in the comments. I appreciate you being here. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.